That kind of shocked her. And she just didn't believe it. She continued to conduct the meeting. So she called for the creditors. No creditors answered. When she called for the creditors, we echoed her. Is this creditor present? So our trustee played the part, okay? And so then, since there were no creditors, automatically the current trustee becomes the permanent trustee. Well, she was no longer permanent trustee. See? Of course, she wasn't believing it at the time, but we did the procedure even if it was in parallel to her. That created a certain amount of confusion in the courts. So we never finished that case because the one who did the bankruptcy ran out of steam. It was too bad, you know. Not everybody sticks with their cases. Yes.
If you wanted the creditor and not name on the petition file, can you still
absolutely
complain or anything with the publishing?
Absolutely. You can let the if you're a creditor who has not been named, that's a fraud upon the court. And you can notify the court and let that court know that you are in fact a creditor, and you present your bill. And there's a procedure for doing that. You'll have to look up the bankruptcy procedure. Now understand that there's been a very recent change in bankruptcy law. What is it, effective October 15th or something like that? I forget the date. Yeah. Just a few days ago. And they've made bankruptcy more difficult too. I think they want to bring back the debtors' prisons if they can. But basically, it's more corporate favorable now. So you always have to be up on these rules because you are definitely playing their game to some degree. Okay. So this, yeah.
Just out of curiosity, you started off that story by saying she declared bankruptcy in a court of record. I mean, is that a common law bankruptcy? I mean, is that
actually
court of record?
Actually, bankruptcy is a kind of a special thing. The concept of bankruptcy has been around for centuries. And when they wrote the Constitution, I believe the Constitution says something to the effect that the Congress should make uniform rules of bankruptcy. They basically took it out of the state's hands and had the Congress define what bankruptcy is. But as I understand it, the states are supposed to do the bankruptcy according to the federal rules, and that's a constitutional thing. But so I suspect that the federal bankruptcy courts are unconstitutional, but I don't know that. I'd have to read that more closely. But in any case, the Congress does set the rules, regardless of who it's for. They do set the rules. So it's a statutory animal in a sense, or a constitutional thing. So what the common law is, you see, the thing is that you can set up a court of record and designate any rules you want. Now, what I like to do when I set up a court of record, I will invoke the rules of the jurisdiction that I'm in. Okay, because frankly, there's nothing wrong with those rules. The big problem has always been with the improper use of discretion on the part of the judges. You know, if you had fair judges, we wouldn't have to be doing what we're doing.
So, are you saying that one could set up their court of record as a common law court and declare their own bankruptcy laws? Or
yes, you could do that. But I don't know that you would get the recognition, you see. So again, what's the purpose of a court? It's to put on a show to convince everyone else that the sovereign is right. Otherwise, you're going to have to switch hats and wear the court jester's hat.
So you could assume the common bankruptcy rules in the area, but remain in control as a sovereign.
Sure. But what you do is you decree them. See, the essence of sovereignty is that the sovereign decrees the law. That's in this website. Okay, you decree the law when you set up your case. In fact, I have it right here. And say, at the commencement, right here at the commencement, you decree what the law is. Okay? So, that's a sovereign decree. All you have to do is say the law is decreed as follows, and then you list it down, what it is that you want to be the law of the case. But I'll adopt the Federal Rules of Civil Procedure, or I'll adopt the California Rules of Court, or whatever state you're in. Again, my own research has shown me that the rules are eminently fair. Okay, I've never. There's always a way. If I'm in a high moral position, on high moral ground, I find that often, in fact, nearly all the time, I'm in agreement with the rules. Our problem stems solely from the fact that we go into court and we don't know the procedures, and the people that we're up against have no sense of fair play, and they're there to win, not to attain justice. And so this is where the real problem comes in. Well, that's why it's necessary for us to do this. Yes, sir.
Two things. One of them is the U.S. is under bankruptcy court, and they've been there over 50 years. There's a thing in bankruptcy through the Bible which says a year of Jubilee, which is the 49th year, and all debts are wiped out at that time.
Sure.
Another point that you make in your disc is bonding. Bonding companies will not bond a statute unless it is something that they can be assured that they will win.
Of course.
So all of your laws are looked at by bonding companies, and they're good laws, as you say, only because they are assured that they will win on them, and they don't have to pay out.
Well, that's logical. Who wants to back something he's going to lose on? I understand that. And as far as the biblical angle is concerned, biblical law is not secular law. Yes, sir.
The United States is out of the bankruptcy. It's a debtor nation now. It's no longer in bankruptcy. It was taken out in 1987.
Oh, okay.
It's been published and published and published. The Congress took us out of the bankruptcy.
Oh, okay.
The last 2 years of Clinton, we were in the positive in the trillions of dollars. And then Bush took us back out and put us in debt. We're no longer a bankrupt nation.
Right. Well,
Congress decreed it.
if you, let me show you something here. Here's a little article, Rules for Changing a Republic into a Monarchy, written in 1792. It goes into the subject you were just mentioning about debt. And basically the writer of this, he basically says that you got to have a lot of debt. It says it's divide and conquer is the rule. I guess it's in the article anyway. Here it is, number 8. The ways in which a great debt so constituted and applied will contribute to the ultimate end in view are both numerous and obvious. The favorite few thus possessed of it, whether within or without the government, will feel the staunchest fealty to it, and will go through the thick and thin to support it in all its oppressions and usurpations. The money will give them consequence and influence even among those who have been tricked out of it. There will be the readiest materials that can be found for hereditary aristocratic order, whenever matters are ripe for one. A great debt will require great taxes, many tax gatherers, and other officers, and all officers are auxiliaries of power. Heavy taxes may produce discontents. These may threaten resistance, and in proportion to this danger will be the pretense for a standing army to repel it. The standing army, in its turn, will increase the moral force of the government by means of its appointments, and give it physical force by means of the sword, thus doubly forwarding the main object. This is 1792, this guy wrote this. Now this guy was on our side, okay? But he was saying, look, if we're going to lose it, this is how we're going to lose it.
Go back to the title on that.
Okay. Rules for Changing a Republic into a Monarchy is the title. We'll go back to here. It's on the website under Essays. Okay.
Is it on your website?
Yeah.
Yeah. It's on the...
That's one of the original articles I put up there. Okay. So anyway, what you have here on the screen is a rough outline of what these are. So now, let's jump from that over to the back to here. This, as I said, you start off with a declaration. Now, once you've made your declaration, made your charge on those various things, either tort or contract, now it's going to be answered by the other person. And the other person, the defendant, has a tree structure that he can walk through to choose how to answer. So he basically starts off with one of two choices. He can either demur or he can plead. Okay? That's the first choice. Now if he demurs, that means he brings up an issue of law. See, when you file a lawsuit, basically you're covering two areas. One area is called facts, the other area is called law. Now, law is what you cover first, the jurisdiction. Okay? And once the law is established, then you go into the facts. It's very important to do it in that sequence. Now, when he responds, he can plead, which means that he's arguing against various things, or he can demur, which means he's only arguing the law. So if he argues the law, he's got three choices in a demur. Oh, I'm sorry. I'm sorry. When he does a demur, what he's really doing is he's saying, I agree with all the facts, but the law stops you. Okay? That's what a demur is. He's going to argue only the law. So when he agrees with the facts, the court now has a choice. The court can now rule on it right then and there, because there's no facts to argue about. All you do is apply the law to the facts. Okay, that's what they did in Aurora's case. They all demurred. They all agreed they had no jurisdiction. They all agreed that she objected and they ignored her. They all agreed that she had done no wrong. Okay? But they were prosecuting anyway. So, that's what happens in a demur. You agree to the facts. And now the law gets applied. So the court has a choice. The court can choose to go straight to judgment, or the court can say, rule on the demur, and then toss it back to the defendant and say, now answer it. Okay? Or they can toss it back to the plaintiff and say, rewrite your complaint or something so that it passes this test again. So that's the demur. If the defendant chooses to plead, then he's got two other choices. He can either put in a dilatory plea, or dilatory plea, I guess, or a peremptory plea. A dilatory plea is an attempt to stop the judgment, any judgment on its merits. In other words, we don't want to deal with the facts. And so in a dilatory plea, you can say, well, look, there's no jurisdiction. Okay? Bring up law. It's kind of like the demur in a sense. But in a dilatory plea, if you challenge jurisdiction, then it goes to a law trial, meaning no jury. See, it's the province of the jury to judge the facts and the province of the court to judge the law. Although the jury can take over and judge the law if it chooses. I mean, that's your jury nullification principle. But the basic normal division of labor is that the jury takes on the facts, the court takes on the law, and if everybody's agreement on the facts, then there's no need to have a jury trial. Okay? So you have in the dilatory plea, if you challenge jurisdiction, you go to a law trial. On the other hand, you could do an abatement. Okay? An abatement is another category which I've never fully understood, and that, but basically involves law again. Okay?